The world turns, and with each turn, a change. And each change makes it more complex, unpredictable, enigmatic. The world keeps turning. And from the Pellicer and Heredia practice, we anticipate everything that is going to happen. Brexit, artificial intelligence, new commercial borders, legal tech. The world keeps turning, and it commands the reliance on international lawyers who are capable of interpreting this new reality with integrity, honesty, and transparency, offering answers to so many new questions. Whatever it is, ask us. At Pellicer and Heredia, we know how.
Good afternoon, everyone. Thank you very much for joining us today. Today, we're going to talk about the Alzheimer in Spain and what the law states and says about it. I'm going to introduce in the panel, I have an expert on my right-hand side. I have Michael Davies, a lawyer, international lawyer in Andalusia. Hello, Michael. Good afternoon.
Hello, Ignacio.
And we have on the other side, we have Pedro, another international lawyer expert in the Alicante region. Hello, Pedro.
Hello, Ignacio. Hola, Michael.
Hola, Pedro.
And today we've been thinking that it was a good topic to talk today about the illness or the disease of the Alzheimer, all that really affects people, and how could we prevent legal situations when the phase start at the very beginning. Michael is an expert on inheritance in Andalusia and all over, and he's been an honorary consul, British consul, and he's got a lot of expertise on this field, and we thought it would be good to share all this information with you. Michael will tell us from his experience how he's been dealing with this situation for clients and from a personal point of view. Then afterwards, Pedro and myself, we will start the questions and answer, and we could discuss it all over. The webinar is going to take us 1 hour of our time, and we hope it's useful for you. Over to you, Michael.
Hi, Ignacio. Hello, everyone. Ignacio, thank you for inviting me to this webinar. For those of you that don't know me, my name is Michael Davies. My firm's called Davies Abogados, and we're based down here in the south in Marbella and Majaca. Okay, so the subject that we're going to talk about today is something that we have come across quite a few times over the last few years. It's touched us personally as well, because my father actually had Alzheimer, so we sort of know from that. We've faced all these things firsthand. It's a bit of a gloomy subject. I know it's a bit, it is a gloomy subject. And we know that maybe lawyers are the last thing on your mind when someone's been diagnosed with Alzheimer. But this webinar is it may sound a bit blunt at sometimes because but it's an ugly subject, and it's better though to get all these legal things out of the way to at least not make the situation worse. So from the experience of over 25 years and of having been in this situation many times before, these would be my recommendations of the things that you can do from a legal point of view if somebody in your family with assets in Spain has been diagnosed with Alzheimer. So we're going to talk about two main things. That is the will of the healthy spouse, and I'm sorry I'm going to have to say it this way. We've got a healthy spouse and the spouse that's been diagnosed. So we're going to talk about the will of the healthy spouse, and we're going to talk about a power of attorney for the person that's been diagnosed with Alzheimer. And at the end, we're also going to talk about, it's secondary, if you like, in importance, about the actual will of the person with Alzheimer. Okay, and that the objective of all of these recommendations is basically to avoid sort of the following sort of situations. There may be quite a few more. One would be a situation in which the spouse the married couple, one of them diagnosed with Alzheimer and now seriously ill, is trapped in Spain and cannot sell their asset to, for example, move back to the UK or to get money together to help with care, to put the ill person in a home. To be able to avoid the possibility of not being able to access bank accounts. Also to avoid, for example, a situation where, 10 years down the road from the moment that the diagnosis happened, the person now is very ill, has lost consent, and at that time, suddenly the healthy spouse dies and they haven't changed their will. So the asset is being left to the person with serious Alzheimer, and of course they can't accept the inheritance. Again, he's trapped because he can't sell the asset even if he wants to, etc. Now, all these recommendations come about because in Spain, and it comes to as a surprise to a lot of people, if the person has already got to the point of complete loss of consent, they cannot sell their property, cannot access their bank accounts, but to be able to do that, you'd have to go through a procedure called incapacitation procedure in the Spanish courts that is very complex and takes a long time, much longer than what it takes in the UK to get a lasting power of attorney using the courts over there. So we need to sort things out beforehand. Okay, so let's dive straight into the recommendations. So the first thing is, if a couple comes to us and, one of them has been diagnosed with Alzheimer, let's call them Anne and Fred. Fred's been diagnosed with Alzheimer, but he's still okay. He's got perfect consent. He's just been diagnosed. It's early signals. That's the moment in which we can really be of help. Lawyers like Ignacio and Pedro up in the Valencia region or us down here. And what we're going to do is recommend the following things. One, we need to talk about a power of attorney. In other words, we basically would recommend that Fred does a power of attorney, enduring power of attorney, signed in Spain to either his wife or his wife jointly with one of his children, one of their children from previous marriages and things like that. Sometimes there's a bit of a mistrust, so maybe a joint power of attorney. There's lots of variations. The power of attorney can be done jointly or jointly and severally, so you can leave it just to your wife or to your wife and one of your sons back in the UK. There are different ways of doing the powers of attorney, different variations, and also with different faculties. No, total power of attorney. You can also make the power of attorney so that it only kicks in once you are over a certain degree of capacity. So, for example, when you're 70% incapacity, that's when the power of attorney kicks in. Or you can make it valid right from the very moment and state on it that's going to be enduring, so it lasts all the way over until you've already lost capacity. That's the power of attorney. The power of attorney in itself, we could talk about it for a whole hour about the different variations. But what's important is that you talk to your lawyer about it, your family lawyer, and he will go through the different variations. Some are more practical, some are safer. There are different alternatives. Then there's the will. We always think that it's a good idea that the healthy spouse rethinks their will, because if they've got a will, if, say, in this case, Anne has got a will that leaves everything to Fred, well, maybe that's not the right idea, because Fred's okay at the moment, but if we don't look into it in the next 10 years, in 10 years' time, Fred may be seriously ill, has completely lost consent. If suddenly Anne dies one day, he's called to inherit. Now he can't accept the inheritance. All the kids are trapped because nobody can sell the property. And remember, we may need to sell the property to be able to have access to funds to look after Fred. So we're not helping Fred by leaving the asset in his name. There are different variations that one can do on this for the safety, different safety, practical, the different things that one can do. It, of course, all depends on the family situation. Are the children from other marriages? Are they not? Different things. Obviously, the simpler the family is, if there are only two children, they're from the same marriage, things are easier because there's less mistrust and things between, future possible beneficiaries of the estate. And lastly, the one that's most difficult to discuss because it has a sort of a nasty connotation to it, and that is that I would also speak to Fred about him looking into his own will, but not because we expect he's going to die soon or anything like that, which sometimes it's difficult to talk about that. And that's why I left it until last, because by talking about a will to someone that's been diagnosed with Alzheimer, it's almost as if we're saying you're going to die soon, which is not the case. Of course it's not. But sometimes it's a good idea because it actually empowers him. In other words, he's got his will. People, do their will and they don't touch again for 20 years, 30 years. So now that we're all sitting down, maybe Fred wants to have a look at his will, because it may not have the beneficiaries that he wants on it, because he may not have looked at it for 20 years beforehand. So before we all forget about wills for another 20 years, and remember, next time we speak in 10 years' time or 15 years' time, he may have lost consent. It may be the last chance, the serious last chance, to really reconsider his will and just make sure that he's going to achieve what he wants with it. We always talk about, when we're in these meetings, we do always touch the will of the person that has been diagnosed with Alzheimer, but we always do it sort of as a last thing after talking about the other more important things, so it doesn't look as if it's the center of the meeting, which it isn't, but it should be, I think, dealt with as an afterthought. I think that's in a nutshell. I mean, it's the main thing is that some people don't deal with these things because they think that in Spain it's just as easy as in the UK to get authorization from the courts to sell an asset of somebody that's already lost consent. In the UK, it maybe takes 10 weeks. In Spain, it can take a year and a half. That's why in Spain, we do it before the person has completely lost consent. That's when we have to deal with this subject. I mean, I know that you up in the Valencia region have got lots of experience dealing with these matters as well. I'm sure you've gone through the pain of an incapacitation procedure. I don't know how long it takes up there, but I mean, here in Andalusia, it's a year and a half, and it's very frustrating for the person that's got the Alzheimer, because they have to cross-examine them, the doctors do, and all sorts of things, and it's much uglier than dealing with these other things that we've just mentioned. I don't know what you think about it up there in the Valencia region. You've told me I had 10 minutes, so I've done it in 10 minutes. We could go on for
okay, thank you, Michael. Yes, actually, I don't know if Pedro wants to join now with the conversation with Michael. Michael here, basically, if it's going through the courts, it takes time. It's terrible when you need to really go through the courts. Because it's out of your hands, it's out of control, and you really don't know. Well, especially to sell a property, that's very difficult.
One of the things, because we've got a little bit extra time, so it went quite quickly. One of the things that the lawyer that they actually talk to, if he's on the ball, that he'll fine tune the powers of attorney and things. For example, if somebody is remarried, he's on his third marriage, and he's got children from other spouses previously, and his beneficiary of his will already wasn't his wife, or the wife only received a life possession with everything else going down to the children of his first marriage. If we start detecting things like that, well, then it wouldn't be logical to ask him to sign a full power of attorney in favor of his present wife. Why? Because then the children could dispute it, because she may sell the property and keep all the money or whatever. We always like to line it up a little bit, the power of attorney, with the beneficiaries of the will. In other words, if somebody, to give a full power of attorney to somebody who's not the beneficial of his will seems a bit strange, because that person could use the power of attorney to abuse it, and then the children will probably end up disputing it. We like to line it up. And when there are children from other marriages with which, for example, the client still gets on well, there's a fluid relationship, and they're going to be beneficiaries, we like the solution, and I don't know if you do it up there as well, we like the solution of joint and severally powers of attorney to the spouse and one of the children from the other marriage, so they both have to, at the end, agree on the sale, and then we just feel it's just safer and more in line with what the client. So there are different things like that. That's just an example of things that really need to be discussed in depth with the lawyer that's going to advise you.
Actually, Michael, you brought up a very good point here. When things are a bit complex, joint power of attorney is very, very protected. That's very, very good, because that is the way to do things in one way, for the benefit of the family, for the benefit of the beneficiaries, So I think that could be a very good solution. As you said as well, Michael, about making a will, that's important, because the fact of changing the will is really going to affect. I mean, it's a very delicate situation.
It's very delicate. It's very delicate.
Because you never know what is going to be the circumstances that is going to happen, who's going to go first. Because sometimes, you could even have a car accident, or who knows, you see?
Yeah.
It's hard to know. And then obviously, Michael, the inheritance tax planning, I think probably it could be a very good point of drawing up a new strategy, a new scenario, tax efficient. So I mean, it's the right time. Let's say being diagnosed with Alzheimer, I say, well, now is the right time where I could work out the best way forward with power of attorney, with wills, and taxation. I mean, obviously,
Yeah.
an indemnity now is very good as well, obviously. But,
Yeah,
but it's worth, Michael, because
what we find is that sometimes people don't want to confront this because it is an ugly subject, and that depends on just how delicate the lawyer that they go to see is on treating this sort of situation. But unfortunately, sometimes people just leave it until it's too late, and by the time they come to see us, the person was diagnosed 5 years ago, and already they haven't got consent. And as you know, there's a point over which, once you're over a certain level of incapacity, you won't be able to sign the power of attorney or sign a sale or sign anything. So by then it's too late for these solutions that we're proposing. You have to be able to understand exactly what you're going to do, and be fully aware of everything, because there's going to be two filters for that. There's going to be both a solicitor that won't take on this work if you haven't got consent, and also the notary, when you go to sign all these documents, who will also want to make sure that you know what you're doing at that time.
Michael, I don't know if Pedro, would you like to add something to what Michael said, or we should just probably?
No, I mean, let's go through. I mean, obviously, we got all the situations that you've described. We have happened in the law firm many times, and when someone comes, and obviously the solutions is obviously to start a court proceeding in order to give authorization by the judge in order to design one of the family members or whoever is the most or the perfect person to represent someone, which is not valid to decide on the assets, on the personal life, but having this prevention. I mean, having signed a power of attorney to prevent those situations in case that someone starts something. Michael said about this starting point when you understand it's going to happen, when the first phase of the Alzheimer it comes, so you are still capable to decide what's going to happen, or what you would like to represent, or what would you like about your assets, or what would you like about anything. That's the point, in order to prevent some of the consequences that may delay and may struggle financially and obviously personally to the family members. But both of you have said, I mean, I agree on that. Yes, absolutely. But we've been years and years saying that this is extremely important. Obviously, in someone, because we have a lot of clients that are expats living in Spain, and the family members are still in their home countries. And obviously, with this power of attorney, you eliminate a lot of situations that will reject you in any consequences, like selling a property, like any decision that you need to take on assets, on personal life. Really is a lot. Will give you all of possibilities in order to do things a lot easier, and at the end also a lot cheaper.
Absolutely. I mean, the worst case, sort of the situation that we've come across quite a few times, I mean, over 25 years, but quite a few times, has been a typical situation where the lady is healthy, but she's 70 something. The husband's got Alzheimer, already really advanced, and of course now they want to sell the property because they need the money. They want to go back to the UK so that they can get more help from the children and things, and they can't afford to do it without selling the property in Spain. And suddenly they realize they're trapped because they can't sell the property in Spain All they're being told is, the lawyer that we've got to go through a procedure now that may take 1.5 years, 2 years, we don't know, and the cost of it. And of course, this lady is like 80 or 79, desperate to get herself back to the UK because she's going through one sleepless night after another with the husband with Alzheimer. She's absolutely desperate. I've been in that situation now a few times, and it really is heartbreaking. And the only way of really of doing the solution is to face these preventive measures well beforehand, 10 years beforehand, basically, so that we don't, so that problem doesn't actually arise.
Well, Michael, actually, as you point out, the joint power of attorney is a key case. I mean, I could understand somebody saying, I'm not going to grant power of attorney because that's a very powerful legal tool. Okay, but you could do it jointly and jointly with even your solicitor. So you could do the wife, the solicitor together if necessary. So the solicitor will only do it when it's really necessary. That's another protection or a beneficiary, as you said, Michael.
People need to understand this system correctly, because we've seen people that have signed powers of attorney and then they've actually signed something different than what they thought they'd signed. This jointly and severally. In Spain, it's the solidario or mancomunado. They get very confused. So you can do the power of attorney to two people in two ways. One, so that either one or the other can sign at any time. Or the other one is that you make it obligatory for both of them to sign at the same time. One, of course, is the one that offers the security and the one that we like using when there's like a spouse and children from other marriages, and it makes things very safe because you say, well, I want to give power of attorney to my spouse, but I don't trust her 100%, so I want to make sure that my son back in the UK also has to sign together with her, or my lawyer in Spain, somebody that has to sign jointly. And some people, they think they've signed it that way, and then what they've done is signed it solidario, which means it's either one or the other. But I say, so it can be done in a way that's very safe, really. That is you can give it to one person, two person, three person, four people, so that everyone has to sign. At the end of the day, especially we're talking about something really important like selling your home, for example. But what harm is there? The way I see it is, what harm is there is, if you've got a property in Spain, you've been diagnosed with Alzheimer, you do a last resource power of attorney, in which, for example, you give power of attorney to your spouse and say your 4 children, so that all 5 of them would have to sign the sale of the house if it ever comes to the point where you've lost consent and you want someone to take over. But if you do that in advance, you've been the one that's made the choices. While if you don't do it, it's going to be a judge that decides who's going to sign for you.
That's very good, Michael. Shall we start just running through possible scenarios, Michael and Pedro? Because I think the more we talk over the subject, I'm sure we're going to have a lot of questions and situations, and every single one is different. You made me think today now about the situation of somebody willing to leave something in a will to the wife. Okay, second marriage, but as well wants to protect the children. And you said exactly it. If I leave everything to my wife, especially if she's got Spanish law, Michael, because if the lady has...
Sorry, Ignacio, I was right. I was reading the questions and I lost you.
No, I'm saying that we have a interesting case, which is basically one person which got English and American law, and then you want to make a will. Obviously, it's your decision. You want to live it in certain ways. Let's put it this way: a little bit for your wife, a little bit for your children, etc., etc. But if by any reason they leave everything to the wife, sometimes depending on the applicable laws, Michael, let's say the wife is Spanish. If I leave everything to my wife, I'm American or I'm British, freedom of ownership. Yes. I transfer everything. I make a will and I say I give everything to my wife. My wife is Spanish. If my wife is Spanish, my children will never get anything, because once I transfer everything to her, she will not be able to transfer. You see what I'm saying? So it's a very delicate, and very important.
If she has children of her own, then
Correct.
of course it'll have to go down to her. And also,
Correct.
and also, even if she wasn't Spanish, that she was English, if you leave everything to your spouse, he or she can then go and change their will and leave things to their new spouse or to other people. So
exactly. Yeah. I mean, I know there is a way to protect. I mean, you could leave the life interest, you could leave percentages. So that's why I consider it's very important, Michael, to discuss it with their lawyers. Everybody will discuss it with their family lawyer or independent lawyer, because every situation is different. Everything is delicate. And I agree. One mistake, I leave everything to my Spanish wife. My Spanish wife will never be able to give my children, because plus the tax, Michael, because blood children, they're not her blood children.
No, they're group 4. They're group 4.
So therefore, they're going to pay a higher tax. And now we need to use the efficient way, which obviously, as you know, is a 99% reduction on the tax in Andalusia, in Balearic, and Madrid and Valencia. But Michael, I think everything is important. Power of attorney is important. Wills are very important. And if you could spend the time to think of possible scenarios, I know it's difficult, but the more we could face it before and prevent any potential discussion with family, the better, I think. Sometimes it's difficult, you see. But as I said, me living to my wife is Spanish. I have children from a different marriage. Obviously, I want something for my children, so I really need to leave that to my children. And then for the sale, I don't know if you heard, Michael, I don't think it's only in Alicante area for power of attorney now from now onwards. For NI numbers, they're not allowing any more public notaries from abroad, having it translated, probably because of fraud. And now all the abroad power of attorney, at least in Alicante police station, I think it will be general. It could only be signed either in Spain, in a public notary, or in the Spanish consulate abroad. And that's going to generate a lot of issues because, it's not...
it hasn't happened here yet.
Not yet. I mean,
it
will
does,
happen. They say is going to... they're already telling us, be aware that power of attorney now, they will need to sign, let's say the beneficiaries, they will need to sign in front of a consulate, over there.
I think
so
that requirement about maybe 10 or 15 years ago, for about 7 or 8 months, they put that requirement into force in the Almeria police station, and then but it was an illegal requirement, and in the end, the Law Society intervened, and they went back to the old system. I don't know if it's just like, and that decision was taken just by the chief of police down here in Almeria. It was on his own sort of decision, and I don't know if that's the same thing up there. And it's going to be resolved then. I haven't heard anything down here at the moment.
Regarding power of attorney here, I mean, obviously, if it's from UK power of attorney or from different countries, where the situation of the position of a notary, a public notary, is not the same, or intervenes in a way that is different from the way that intervenes the notary in Spain, let's say, we've seen sometimes power of attorney that is being made by attorneys, which obviously we will not be able to be working in Spain as representing someone in a public deed. And we've seen that sometimes a notary of public deed has been authorized just the signature of whoever signs that document.
That wouldn't be allowed, yeah.
But that one would also be allowed. But obviously in the way that the conditions that intervenes, informing, advising, and is a public notary designed or chosen by the government as it is in Spain, as if it were similarities as it is in Spain, that should be working, obviously, in that terms.
Yeah. At the moment here in Almeria and Marbella, nothing's changed. At the moment.
I understand it's because of a fraud in Alicante. It's been said, well, power of attorney from outside Spain doesn't work. Full stop. Obviously, this is not.
I mean, probably, Pedro, is because of the fraud. I don't know.
Yeah.
They were caught recently. Michael, with the appointments for the NI numbers and the TIs and everything, there was a ban that nobody could get the appointment. So probably I don't know if that was like a drastic decision from the police, or which I agree with you, because I thought, well, I mean, power of attorney is legal wherever it's
legal,
it's being legalized, and with the Hague apostille, and you can still buy a property with a power of attorney. But they make it difficult, Michael. You see, they make it difficult.
No. That's right. No. If they say no, you've got to denounce them, and then they sort it out. It did happen years ago here. But at the moment, nothing's changed. So with a bit of luck, it's maybe just something that they're doing up there, and then maybe the Law Society can write a letter. Because obviously, if the power of attorney is legal, regardless of what they say, they can't say no to it. They shouldn't do.
Right, let's just jump on to questions. I mean, we've been talking about a lot of financial, Heather is saying here, financial aspect, which are important. Is there anything in Spain about who can make medical decisions if a person no longer has capacity, which I think is an excellent, Michael, question from Heather, because in the power of attorney we've been discussing, there is a specific clause that allows the family members to make decisions if you just basically do not have capacity. Could you explain a little bit that clause, Michael, which is basically and then authorizing your family members or people to make any decision when they're in hospital?
So there's the power of attorney that we're talking about, that we've been talking about so far, is along the lines of a financial power of attorney, as you do in the lasting power of attorney in the UK. You can do another document called Testamento Vital, where you go into the details of medical situations and things like this. Now, here in Andalusia, there's two ways in which you can sort of do that document. One, you can do it at the notary, in which case the lawyers like us, we can prepare it, take it to the notary. And that just basically sort of, euthanasia is not allowed in Spain, but there are different degrees of where they can turn the machine off, not turn it off, there are different things like that. And you can leave it all established in a Testamento Vital, and also on that same document, say you want to be cremated, not cremated, and things like that. Now, in Andalusia, I don't know how it works up in the Valencia region, you can also do a document for free at any of the public hospitals. And then theoretically, you fill it in at the hospital, it goes on a database, and then regardless of wherever you are in Andalusia, they can always access on your medical card that document with all the wishes that you've put forward, because there's a lot of multiple choice questions and things about, when they can switch off the machine, when they can't, and all these things. I don't really know how that works. I know it's for free, and I know clients have told us after charging them to do it at the notary, they've said, well, I could have done it for free at the hospital. It's true, but everything public is not normally very user friendly. I expect it's all in Spanish. I don't know how it works. We never sort of insist too much on this Testamento Vital, but sometimes people do ask us, and we prepare the document. The advantage of doing it in the hospital is that technically and theoretically, it's always available to the doctors if they go into your medical records, but you're dependent on that system working. While and of course, it has to be a public hospital, not a private one. And if you do the one at the notary, well, you've got full control of the document. The document's there with you, and you've got it wherever you go. The disadvantage that you've got to carry it out. I, in general, I think I would probably go with the one signed at the notary, because I don't know. I don't know how it works at the hospitals, but knowing how sort of the bureaucracy works, I don't trust it too much.
The way we've done it here, Michael, is you do it in front of a public notary, because once you do the financial will, some clients want to do the vital will, and then we do it. And then you need to, the notary informs Social Security, but you need to probably, but you need to register the will, even though it's connected, telematic, but in the old days, we used to report a petition or like attaching a form to the hospital. But I agree with you that if it's a private hospital, or at least it's a consent form that you have authorized to donate your body to the science of the university of wherever, even to give full capacity to your spouse to make decision if you're terminal, just to disconnect, because the law made it much more flexible with the euthanasia and everything. And I think it was the law 2 years ago, made it much easier. And we even had some clients that just did sign even that clause.
These documents, I think, if you like, I mean, this really is sort of, gloomy sort of stuff. But basically, if somebody's on their own and have not got a spouse, a clear next of kin, because sometimes the doctors, let's just imagine a case, okay? If someone has got really bad Alzheimer, beyond 20 years of illness, 15 years of illness, completely lost, and they go and they're in the hospital and they go into a coma, etc. But the doctors think that they may be able to bring them back with antibiotics, they've got an infection and things like this. Sometimes the doctors, who are human and etc., they know the person's got an irreversible illness, Alzheimer or very serious cancer, and they know that by not giving them antibiotics, the person will just just die slowly, and that will be it. But they're worried because there's no clear next of kin to tell them that is what they want to happen. Okay,
that's a problem.
So the doctors get nervous and they'll just plug in every single antibiotic they can to try and pull him back, even though they know that the quality of life is zero because of the 20 years of Alzheimer or something like that. So those documents, I think, are useful in that particular case. It just gives just enough sort of strength to the doctor to know whether he can do this or not do that. While if they're nervous, they will just do everything possible to keep a person alive, for example.
Michael, we've been concentrating on Alzheimer as well, but we could extend this situation. We've got a question here about dementia or vascular dementia. We could even think about cancer. Alzheimer is because you lose, and with cancer, you could probably still make decisions, But I still think that all that is being discussed is very useful when somebody is limited from a health point of view. You see, you've got a question here. At what point can they change their will? Can they change their will after they have received a diagnosis of Alzheimer or vascular dementia? If you could just tell them what point. Okay.
This is very complicated to discuss on a Zoom call.
It's difficult to make.
Yeah, it's does the person have consent or not? Do they know what they're doing? Well, the thing is, if you've simply been diagnosed and later on you make a will now, leaving things to somebody, and somebody else disputes it, of course that can all go to court and all this. So it's not easy. Signing a new will, after you've been diagnosed, even though you're perfectly okay, it cannot be guaranteed that somebody could not put a claim against the will. That's the way I think. That's all we can say about that, really.
Right.
In most families and usual families, if the person has got full consent, to a common sense person like you and me, he just goes, the notary thinks he's okay as well, then they sign the will and then it all works fine. But if there's a claim by a child from a first marriage and things like that, things could indeed get complicated.
Valerie is asking, is saying that she
what time is the comment? What time?
Just recently, the very last one is saying, I'm trying to catch up, but they keep coming and coming. But Valerie is just bringing here the very last one, 541. She's saying that she's got a power of attorney from 1979. I obviously would like to just double check that if possible, because who knows how was that power of attorney made and what faculties were made. It doesn't mention, she says the mention, but Valerie, I think here is a matter of a lawyer, of your lawyer, looking through the power of attorney and making sure is wide enough to cover all these aspects.
Yeah, Ignacio, from a practical point of view, I would just say it would be a bit silly to trust that power of attorney done back in 1979. They should do a new power of attorney. I mean, at the end of the day, the power of attorney doesn't necessarily die after a certain given time, but 1979 is probably not even on the databases of the notaries and things. Why risk it? If they're both still okay, sign a new power of attorney.
Right, and we have Rebecca is saying that obviously in the States they have the state attorneys, that's 526 Pedro Michael. They have the state. Well, obviously, if the question is, can we as solicitors, you or as make a will in Spain for assets here? The answer is absolutely yes. I mean, you could do one will in the USA, which is probably easy to enforce it over there, and one for the Spanish assets. Okay, if you had probably nothing else except a bank account, you could even do an international one that works for both, if that helps. Okay, if it's an easy
Ignacio,
one.
with those wills, what we always do. I mean, we always think the best thing is one will in each country if possible. But if they can't go back, what we always do when we do the will in Spain, we just add in a second witness because it makes it easier to convalidate. Because over there, here we use one, so we just add in an extra witness to make things a bit.
Okay, that's a good idea. And then Pedro, would you like to mention to go to any of the questions? You don't have the microphone open, Pedro.
Sorry, I mean
we have Kevin as well saying here.
Regarding Rebecca is the one you are asking, Ignacio, the one you've read?
Well, we just discussed Rebecca, and then we have pending Kevin as well.
They say about the state attorneys. I mean, we're talking about, obviously, I think you said that, but we need to have a full power of attorney authorized by a notary, by a public design, by a government, with the conditions, terms, the capability of, because one of the issues about the notary, when you sign a notary deed, is that they identify you and they see that you are capable. You've been saying about once in the first phase when you are diagnosed about Alzheimer, but you have still capability to understand. Well, that's the best time in order to sign a power of attorney, because even though you've been diagnosed, you are still able to understand what you're going to sign, and you will be capable. I mean, you have a capability to understand what is you're going to sign and understand what is going to be said by you by the notary. So that power of attorney will work on your situation when the Alzheimer goes through. Regarding, I've been reading one of the questions for a power of attorney. I think obviously, as if he's updated, is better, but from 1979, I will ask a copy of that power of attorney, even though it says general power of attorney, which says absolutely everything is in terms. Power of attorney in terms of in general is there's no time really. There's no time to.
Pedro, well,
it doesn't mean that maybe it works in Spain. In this case, this specific power of attorney, maybe it was signed just because some specific point, and now it's been used, so it doesn't work. So I will ask, I think it's Valerie to send us a copy of that if it works, and then we'll be able to check it.
But the thing is, Pedro, with that, the way I think is that, for example, it's over 40 years old, that power of attorney. Yeah. I think if she arrives at a notary in Spain now to sell an asset with that power of attorney, the notary will look for all sorts of excuses.
I mean, that will not work. That will not work. I mean, obviously, if it's someone design, someone has, it's in a, I mean, because we haven't used the word tutor, because when you are tutor, you need to be inscribed in a registry, and to be inscribed in a registry in order to sell the property, that also needs to be used if someone enters in a situation where it's a dementia or Alzheimer on that. So in that point, I mean, even though, and I have to say that the power of attorney, if he has not said anything, it don't have a limit time. In this case, shouldn't work.
And also, yeah, it's true. And also, I mean, the thing is, it may not actually mention capacidad sobrevenida. So when they go to sign with that power of attorney, the notary is going to want proof that that person is still alive for a start, because it's 40 years old. And then second, he may start asking about whether he has capacity or doesn't have capacity, just because of how old it is. If it was 5 years old, he wouldn't ask, and therefore she just do it. But because it's very old, he's going to ask for proof. If it doesn't have, capacidad sobrevenida in it, and it's not enjoyed, he's going to probably ask for proof that he's okay, and that he's not incapacitated, still consent, and that he's still alive. That's what I think, anyway.
Then we have Kevin, Pedro Michael, his sign here. I don't know if you went through 526. I think it could be a difficult one, because his father just passed away. The mother has Alzheimer. Obviously, they've got wills, but I'm not sure whether the will say he goes from to husband to wife, and the wife obviously cannot accept inheritance. That's going to be a difficult one, isn't it?
Okay, so it depends on the wording of the will. If the will may say, I leave everything to my wife, but if she predeceased to see simultaneously or was incapacitated, then things go to whoever. Then if she proves that the person is incapacitated, then we get the next step. If it doesn't say that, what you can do is go to the notary. It's not to the tax office as it says here, it's the notary. And basically, because in this case, she's not disposing of an asset, they're receiving an asset, the notary won't be as strict regarding her situation. It depends. If she's completely lost consent, he's not going to allow her to sign. If she's more or less okay, it may be able to go through simply because she's not disposing of an asset, she's receiving something, and the notary will tend to be a bit more flexible.
Well, they're all resident in Spain, and I think probably if that's not possible, Michael, probably husband goes to wife, wives when the spouse goes, he goes to the children. He has power of attorney, but I think a UK power of attorney, not the Spanish power of attorney, which can make the case a bit more difficult. And probably all the inheritance could be dealt when they both pass away. So, but Kevin, is worth looking and discussing with a lawyer your case, because it needs more specific documents to run through it. I don't know. I think we did cover most of the questions we have here. One probably. Paul is asking about trust status of a property in the UK, Michael. I don't know, the 547 one.
What time?
The 547, probably, I don't know if you want to discuss something about the trust. And Pedro, and you have the one 548.
Yeah, we've been speaking about this, the trust. The trust are not recognized in the Spanish legal system. That does not mean that may be included in a way that the property could be. Obviously, the trust at the end is the one who moves around the assets into the beneficiaries, and obviously it's a matter of how it's done. I mean, if a discretional trust, how this is going to be transferred into the beneficiaries, and if it's going to have like an income, there's going to be an income, and is someone who is diagnosed with Alzheimer or incapacity in a way that is get an income from a trust because it has a property, has some rental, is being sold in a way in the properties or assets that belongs into the trust and managed by a trustee, or then needs to be checked about who is the beneficiary, and if whoever is the beneficiary with Alzheimer, with incapacity or declared incapacity, or not declared and should be declared. And then needs to be included in a way that if it's part of an income or not, or if it's that obviously is something that needs to be checked. I mean, the trust as it is could move assets, I understand, according to UK law, but obviously in the way that the trustees, they receive discretionally some asset, then it will have to be reported into, I understand, into the tax office. Because they are not they are not individually the ones who are legally ownership about this specific property.
Michael, would you like to comment?
My opinion. Maybe I'm wrong.
Sorry, Pedro?
That is my opinion, but maybe I'm wrong, because the trust, we've been receiving many questions about trust, and obviously something that the tax office really on the resolutions, that there are few resolutions on this, even though still are working on that, and we still have very low, but we always apply for the copy of the trust to check if it's discretional. So discretional in a way that the trustee is able to decide whether 1 year is going to receive 1 year, or another year is going to receive 10,000 euros per year, or how he's going to move this money to the beneficiaries, which will be the point to when someone receives income or inheritance on that way. I was going to say something about another question. I have missed.
I think all this is as much as we could say generally. So if you guys have individual questions, feel free to arrange an appointment, a Zoom appointment with either Michael or ourselves, so we could be more accurate. I know it's hard to give so much information on general basis, isn't it, Michael and Pedro?
Yeah, Ignacio, if you just let me have 30 seconds, I just really like to insist on what I think is really the only, I mean, we've talked about so many interesting things, but there's sort of the really, what I'd like everyone to take from this Zoom, this webinar that we're doing today is, you know, if somebody has been diagnosed with Alzheimer or any other kind of dementia, but they're still okay, they've still got consent, I do think you should spend some time just organizing the legal things, okay? And basically, you just have to do the following things with a lawyer, obviously. Number one, you need to look into the will of the healthy spouse. We've explained why. Number two, you need to look into an enduring power of attorney for the person that's been diagnosed with Alzheimer. And now that you're at the solicitor, and as you're there anyway, also take a look at your existing will. That's the person with Alzheimer, your existing will, just to make sure that it does that the beneficiaries are still as you want them. And that would be it from me on this gloomy subject. Next time we'll talk about something that's not as that's more a happier subject.
I know, Michael. I mean, it's difficult to discuss all these things because they're not nice things, but when I'm sure you've experimented a situation where you would have loved to help people if they came to you before. And sometimes the frustration situation is when people don't know. And unfortunately, it's too late. So all these webinars, we're trying to prevent problems, and everybody obviously will have to do whatever they consider is best for them. But I think it's very useful situation, and I'm glad, Michael. Sometimes people say, "I'm glad you told us," and things like that. Paul, Michael has here. I don't know if you discussed about fluctuating capacity, but I don't know if you did fluctuating probates. Are the doctors still?
Yeah, is it a moment that sometimes you are not able to sign a attorney, and sometimes you are. We had a case, I mean, a long time ago. I remember that in the north of Spain, and this is connected also with some question that even before about the loss of consent. It says it is determined by a legal or a medical entity. When someone goes to a notary, I mean, at the end, a notary, someone goes to a notary, and a notary check your capability to sign or not, if you understand or not. Obviously, sometimes the checking is very standard, or is very, I would say, simple. But sometimes, obviously, the notary makes you a lot of questions in order to check if you are correctly understand what you're going to sign or not. Obviously, I think it's a subjective criteria, a subjective point of view by a notary. But obviously, if a notary says that you are capable to sign, that's perfect. The fluctuation capacity, obviously, when someone is undiagnosed, in some ways is having the capability or not, to do it is with witness. And if a witness is I remember when we use it, and there are some legal rules in Spain in order to do that way and verify and authorize that situation, is that in that specific moment, even though has a diagnosed Alzheimer and in many moments is not capable to understand what he's signing, if a medical is also as a witness authorizing at the same time with the notary and with the person who is signing the document, that's perfect to do that way. Obviously, checked by a medical and checked obviously by the notary.
Okay, what I'm going to explain now is not very technical, but it's what actually sort of happens in practice. Okay, on many occasions. Sometimes you've got a family that you've known for many years. You know, there's kids from the same couple, everything's above board, they all know exactly what they are. And, you know, maybe one of the spouses is just a bit wobbly, you know, that their mind's wandering a little bit. And basically this family just wants to sell their property in Spain and get themselves back to the UK. And they're here with their two kids and they just want to help mum and dad because mum didn't do these precautionary things, as we mentioned before. They just let it pass. And now she's a bit, borderline. So they come in one day to go and sign the power of attorney to the children so they can take care of things. And they come into the office and she's just a bit, she's just not, that day she's not good. So what would we say? We say, go away, come back next week, and let's see if your mum has a good day. Okay. And on the good day, she goes into the notary. And in general, when the notaries see that it's sort of, because we're not stupid, we all know, some families, when they've got the kids with them who would be the beneficiaries, they're all together there, you can just tell that there's nothing dodgy going on. The notary will not be as absolutely strict of giving them a 3rd degree interrogation as they would if it's something a bit more lonely, where the lady goes into the notary on her own to try and sell the property and this, that, and the other. From experience, that's sort of how I see it sometimes. And the fluctuating capacity, maybe that's what it is. We've seen them. Some people have good days and they have bad days. Sometimes they know exactly what they're doing, and then the next day they seem to be a bit lost. But of course, what we're saying here is for cases in which there's not likely going to be anyone damaged by what they're going to do, because otherwise they're going to be sued later on. So this is for cases where everything's happy, it's the family, there's nothing, so if somebody comes in and they're going to sell the asset and there's children from another marriage and things like this, well, there's no way that anyone can help them, because at the end, that sale is going to be maybe subject to a claim because mum was diagnosed a month ago, 2 months ago, 3 months ago, or whatever.
Mm-hmm. Okay, Pedro, we're going to wrap up. Anything else you would like to recommend the audience? I think it's been very interesting, and we could be here hours and hours with different cases, can't we? Would you like to say something else, Pedro?
Just to recommend, obviously, to give advice on whenever this situation is going to start, when you realize that maybe it's starting. Obviously, something very, very, we recommend always to have a preventive power of attorney, and in order to prevent situations that may come in the future. And in some ways that you will not have a capability to do it in one term, so you will have to go to court, and will delay, will be more expensive, and will get things more complex. So at the beginning, to sign a power of attorney with, obviously, what we said, with the capability, and in a notary office, when you understand what you are signing, when you understand when you are writing, when you understand and you decide what you would like to happen with your assets or with you, that's fantastic, that's really good. Obviously, when we enter in let's say, a gray area, that you are in a way that you understand sometimes, you are not, sometimes you don't understand, then we enter we need to find really, as Michael explained, the situation where you understand when you're going to sign. Sometimes it doesn't happen. And obviously, when you enter a situation where you do not understand, you will not be subject into the capability to sign a document, then obviously you need to enter in a court a resolution. So what we recommend always is to give apply for an advice in order to do it. It will be a lot cheaper, faster, and easier in the future for everyone.
Michael, anything else?
No, that's a great webinar. Just thank you for doing these things. It's really, I think, really is important. I mean, today I think there's a webinar which is, as I say, when you call me to tell me we can talk about this, well, that's going to be a sort of a, not a nice. It's just not a nice subject. This is a subject that people just don't like talking about, and it is ugly. We've been through it many times before with clients in front of us. You learn as you go. There are certain things that we realize after all these years that you can't say, things you can. It's difficult, but it is very important. And the only objective of this webinar and what we're discussing today is just to avoid people lots of expenses, lots of problems, and in some cases, pretty much horrific situations, okay? And we're thinking about that widow that's trapped in a house in Spain, wants to go back with her kids, and just can't leave because she can't sell the property. That's what we're trying to avoid. That's the only objective of the webinar.
Well, thank you very much, Pedro, Michael. I fully agree. If they could take that, it's worth them discussing with their lawyer this specific situation. It is the number one advice I will tell, because everything is very specific. Two, as Michael and Pedro stated, I think the whole point here, even though it's an ugly subject and difficult one, the good thing here is a matter of helping before it's too late. And the whole point here is doing the process as straightforward as possible. I'm going to pass over to Juan from here with a video, and off we go, and we will be seeing you very soon. Michael, I think your first of, I think next week is a bank holiday, so probably we'll be seeing on the following Wednesday. Okay, we'll see what we talk next time. Okay, let's hope to learn more. All right, thank you. Over to you, Juan Fran. Thank you.
Bye.
When a loved one passes, it takes time to assimilate losing them. At these times, when you least want to deal with paperwork, Pellicer and Heredia are here to help. One of our lawyers will be in touch to inform you about the process and answer all your doubts on the legalities. No matter where the assets and heirs of the deceased are located, and without having to travel to Spain, we can advise you and carry out all the required proceedings in Spain. Obtain the death certificate. Search for assets, debts, and existing insurance policies. Give advice on accepting or renouncing the inheritance in Spain. Hand over information on all the related costs. Pay all the compulsory taxes on your behalf, and translate all the legal documents required. And remember that upon death, when carrying out all these processes, legal deadlines apply. Through this difficult time, when you most need help, Pellicer and Heredia is with you every step of the way. Pellicer and Heredia, international lawyers.